which really shocks people, frankly. There's a smattering of some of the other states to make the point that that it's been kind of well represented in the country. Craig, can you click on the hyperlink for the status of enactment efforts, and then a map should pop up that you can then get rid of after it pops up? Did you double click on it?
It's opening, yeah.
Okay. And I'm going to say, I got some war stories about some of the states I feature and maybe some I don't, that I think we'll deal with when I talk with.
How's that?
That's great. So this kind of makes the point that, you know, we've had it all over the country. So far in 2021, we have 4 introductions in various state legislatures. We are expecting somewhere on the order of another 4. We had a real interesting development, a state that we thought for a variety of reasons was beyond our reach in the short or medium term was California. And one of our new allies, and I think I'll talk about this in a second. Anyway, one of our new allies, state associations of realtors, the California Association of Realtors, decided to champion this a few months ago. I didn't even know because we thought it was beyond our reach, so we hadn't done any outreach in California. One of my former students from Wisconsin is the diversity, equity, inclusion person for the CAR. She told me about it, and I asked, like, well, I never interacted with them, the Uniform Law Commission. And I said, how did they come to that decision? And we've gotten a lot of media attention in the last, you know, like 2 or 3 years, like more than 80 articles, and sometimes in some big publications. And apparently there was a Wall Street Journal article from the spring of 2020 that one of the senior governmental affairs people at the California Association of Realtors saw. And the theme for the National Association of Realtors this year is fair housing. And they actually have come out and acknowledged that they had a tawdry past in terms of discriminating against African Americans and others, and they're trying to do right by them now. And so this kind of fit well within their commitment in the next couple of years to promote fair housing. So as I indicated, we're expecting another kind of 4 states. So that's where we are. And even for 2022 now, we've generated some significant interest in places like Louisiana and North Carolina, potentially Minnesota. So it looks like we still have stuff in the pipeline. So if you can get out of that, right, and go to the next slide. Okay, so just I think we're going to kind of wrap up. There's obviously been growing momentum and evidence of success. So one of the things that we've seen in terms of growing momentum is that there's now been an appetite in a couple of states to even expand some of the core protections of the UPHPA. So New York did that when they passed it in 2019 and provided additional property protections for heirs property owners facing partition. Virginia expanded it a different way. They basically said, well, all of the core pillars of the UPHPA are great, but not just for families who own tenancy in common property, for all tenants in common, even if they're not family-owned tenancies in common. So they basically universalized the UPHPA, and now it applies to all partition actions, whether it's family-owned property or not. In the 2018 Federal Farm Bill, it specifically references the UPHPA, and it gives incentives to states that have not enacted it to do so by essentially indicating that if you're a family that owns farmland or a ranch and you own heirs property, you get a greater access to benefits and programs within the USDA than heirs property owners who are farmers and ranchers in states that have not enacted it into law. And as a direct result of this incentive, a fancy term for that is cooperative federalism, where you have a federal piece of legislation that incentivizes states to take action on their own. As a direct result of that, we have gotten 4 enactments in 2019 and 2020 that were simply beyond our reach. For example, in Mississippi, we had failed twice before 2020, and it seemed like we had no prospect for success there. The Farm Bill totally changed that. And one of our other new allies is the various state farm bureaus. In Mississippi, they championed our act. In Illinois in 2019, they championed our act. And they were actually in Illinois able to beat back the attempt of the Illinois Bar Association to kill our chances there. And then the Bar Association said, no, we don't want to get into a fight with the Illinois Farm Bureau. And so they backed down. Same thing happened, as I indicated, in a couple of other places, right? So that's been, it's opened doors to states that we literally would have had no chance. The second thing is that the provisions of the 2018 Farm Bill, they would be enhanced under a bill introduced by Cory Booker and Senators Gillibrand and Warren that essentially would increase the incentives for states to enact the UPHPA. And then what we're having is, because of the success of the UPHPA, the Uniform Law Commission recently accepted a second proposal to form a drafting committee to address a different manifestation of heirs property, that one that I talked about as gridlocked ownership at the beginning. So this was a proposal I sent to the ULC that they just accepted. They typically get 50 to 60 proposals a year. This year, they just accepted 3 to establish a drafting committee. And this one about gridlocked ownership was one of the 3 they accepted. We're also now seeing in states like Virginia, where after successfully passing the UPHPA last year, there's now been bills introduced to address other manifestations of heirs property, leveraging the success of the UPHPA. I think this might be my last slide. When I talk about positive impacts, there's so I mentioned the thing about we're seeing higher sales prices being yielded, not just in Texas, but I've talked to folks in Georgia and South Carolina who've indicated the same thing, which once again is not surprising when you know the real estate economics theory. We've also seen in some states a dramatic downtick in the number of partition actions being filed, especially abusive ones by speculators and developers. Once again, I've heard that from Georgia. I've heard that from South Carolina. That hyperlink there, I don't know if you want to click on it for a second. I guess I'll tell the war story now about that. So in 2000 I think it was 2018, on January 1st, 2018, the UPHPA was going to become effective in Hawaii, right? On December 31st, 2017, one day before it's going to become effective, Mark Zuckerberg, who owns a huge estate on the island of Kauai, filed 8 or 9 partition actions seeking the forced sale of native Hawaiian-owned property that was within the perimeter of his properties. Basically, he had to grant these families easements to access their property. So he filed partition actions seeking forced sales like a day before. Good for him in terms of like the real estate law, right? Because his ability to get these forced sales was enhanced under the background law as opposed to the UPHPA. The one thing that Zuckerberg did not do a good job is consult his PR people, because when he pulled this move, it resulted in an avalanche of bad media, including this article that basically said he was trying to get around the UPHPA. After a massive amount of blowback, he dismissed all but one of the cases. And in the last case, he said, okay, he wasn't going to seek to acquire the property for himself, but he was going to support one of the family members, so that if he had to grant an easement, as opposed to granting an easement to 40 people or 50 people, he'd only have to grant it to the husband and wife. All right, if you can get out of that, I don't know if that was the last slide or.
One more, I think. Yeah.
Okay.
Let me get back to it. Hold on. There we go.
Yeah, the only other thing, and I got to apologize to Sarah because it took me too long to get through this, but the one thing I did want you all to know is that the ABA Publishing has agreed to do a book on heirs property and the Uniform Partition of Heirs Property Act. I'm the lead co-editor. Erica Levine Powers, who is the chair of the ABA State and Local Government section this year, is my co-editor. And we have a variety of really excellent authors trying to cover really heirs property in a 360-degree way, the urban, the rural, the various communities impacted, things you can do proactively to deal with this in terms of estate and trust planning, et cetera. The role that activists played in the role. So anyway, by the end of this year, this ABA book will be out. Okay, so let me stop talking. And once again, sorry, Sarah.
Don't be sorry, Thomas. We're all here to hear you talk anyway.
Please feel free, Sarah and Thomas, to go about 5 minutes over, because with the weather conditions and everything, we ended up starting a bit late. Thank you.
Okay, sure.
Sure. Well, Thomas, I really appreciate the breadth of your presentation. Actually, as you know, went through a few of the questions that I was going to ask, so we've got those out of the way anyway.
Sure.
One thing I wanted to ask you to do, because we may have some audience members, although all, if not most of our audience members are attorneys, may not be, they may not have thought about property law since that first class that they took back on 1L year of law school. So if you could, just for everyone, really hammer home how heirs property happens generationally, to the point where what numbers of people could be owning through this tenancy in common, and then talk a little bit about how that, well, why don't you say that first, and then we'll talk a little bit more about the implications of that.
Yeah, so it's not unusual in these families to have property passed down like one generation after another by intestacy, like without a will. And it's just not unusual in these families to be dealing with a family where there's 20 tenants in common, 50 tenants in common, 200 tenants in common. And in some cases, you can have like more than 500 tenants in common. And that just makes the property particularly unstable, because any one of the common owners, and so with this type of ownership, what we say is it's undivided ownership. So any individual who's in the common ownership structure, they don't own any particular part of the land. It's like owning shares in Coca-Cola, right? When you're a share owner, you don't own Coca-Cola's bottling plant in Atlanta. You have a fractional interest, right? So any one of the co-tenants, irrespective of the size of their ownership interest, right, can seek a forced sale. Like they don't have to have a 50% interest or a 20% interest or they could literally have like a 1/1,000,000th interest, and they are able to initiate this action and request the forced sale.
Which gets a little bit to the genius of the first part of the Uniform Act that you drafted. I think you're pretty humble in your role in that. Thomas pretty much led the battalion on that act, and the genius of the forced sale provision comes into that idea that there could be there could be hundreds and certainly tens of owners. And then talk a little bit about that moment where land gains in value and is suddenly a target for development. What did a developer have to do in order to leverage that instability? Because
Right.
this really gets to that reason why the forced sale and the partition, the division, is so important to have intervened in.
So what we typically would see in various states around the country is, as I indicated, African Americans, when they initially acquired property, they became kind of elite within the African American community. If you go back 100 years, 80% of the upper middle class African Americans in this country were actually owners of agricultural land. But oftentimes the property they owned more generally was not considered prime real estate. And so one of my good examples of that is Hilton Head Island in South Carolina. Up until 1950, Hilton Head was majority African-American owned. What transformed Hilton Head was that the state of South Carolina then financed the building of a bridge from the mainland out to Hilton Head in the early 1950s. And immediately real estate developers saw and envisioned what Hilton Head actually has become. But they needed to acquire those properties. So typically, and this is true all over the country, what these speculators or developers typically do is they know they only got to pick off one of the heirs or the tenants in common. And what they typically have done is they target one of the family members who's a distant relative, often one who either themselves or their children who or their descendants from a state where there had been northern migration. So oftentimes it's a family member who's a distant cousin who didn't even have any idea that they had this fractional ownership, right? Whether they're in Detroit or Chicago or LA or whatever. And so when the developer calls them up or a speculator calls them up and says, hey, I noticed you have this tiny interest and I'd love to just buy that out. Well, before the phone call, they didn't even know they owned the interest. And then the developer offers them some minimal amount, even like an amount below the market value of their fractional ownership. But they think it's free money, like whether it's $500 or $1,000. And now you have that developer is now, quote unquote, part of the family, fully entitled to file a partition action and request a forced sale. And that's typically what they do. So they had little incentive to buy out a number of family members because they just needed one, whether that person owned a 2% interest, a 3% interest, whatever, right? And that's typically what they did do.
Yeah, so really important to be able to have that intervention that can slow that process down and have the courts look carefully at what's happening.
Mm-hmm.
Also, since we have a crowd of attorneys listening, and we can say words like tenancy in common and have people understand what we're saying without having to explain too much, or intestacy. I think I'd really love for you to help these attorneys understand, let's say that they're inspired to get involved with this issue and in their work and in their advocacy. How can they do that with their practice and with their advocacy skills? What organizations could they work with, and what can they do? What are some pointers you would give for intervention?
So I think there's a variety of ways. Some could be participating in both, continuing legal education seminars, right, to help those who, practice in real estate or wills, trust, and estates have a better appreciation of this phenomenon, thereby, whether themselves or others, they can inspire to take on pro bono cases or to offer a reduced fee to families who are in this circumstance. Because in my experience, and maybe it's different today, I was in practice more than, 25 years ago. I practiced at a large law firm in Washington, D.C., Covington and Burling. But when I was at Covington, almost all of the pro bono opportunities were really for litigators. And we only had scant opportunities for transactional attorneys. But there's a huge role if you think about transactional attorneys as trying to help address something like the racial wealth gap or preservation of wealth within certain disadvantaged communities. There's a huge role for that. So that's one way you can do. But even beyond the CLEs, a number of organizations like the Georgia Heirs Property Law Center in their multiple sites around the state of Georgia, maybe even Georgia Legal Aid, do things like community legal education or community legal education workshops, right? And so that the various community legal education workshops really has been incredibly helpful for the families to basically understand what their legal rights are and how they could better protect their properties. So that's one way of getting involved. If you want to then think about it in terms of advocacy efforts, we've had kind of great support in various states in the country, including in Georgia, by attorneys who have supported the effort to get the UPHPA enacted into law. There's, as I indicated, likely in about 2 years, there's going to be this second Uniform Act that's going to make it easier for families who own tenancy in common property to transfer their form of ownership to something that is far more stable, far more rational. And we always would welcome attorneys who want to get involved and bar organizations to support that. I think in Georgia, we had the support of the Georgia Bar. I will say that we've kind of had a mixed record in states. You know, in a number of states, we've had the support of the Bar Association, but our biggest opponent also has been various state bar associations. So anyway, the lawyers and bar could play an important role in helping further the effort to change the property laws to benefit these families.
I muted myself.
Yeah.
Well, thanks for those pointers, Thomas. And I would point out that somebody on the call has shared their screen. And if you are that person, you may want to stop sharing the screen. So yeah, thank you. I'm sorry, I'm just refining my position. You talked about tell us more about your experience with the Uniform Law Commission. So if people are thinking about getting involved with the ULC, do you have any insight or advice that you would share? Any specific lessons learned or thoughts about that process of uniform lawmaking? Because I think that's a really interesting aspect of the way that you approach this problem that you identify through your work and your research and your practice.
Yes, I think sometimes the Uniform Law Commission is not generally very well known, even among lawyers and law professors. I mean, I forgot that I didn't know much about the Uniform Law Commission prior to being tapped to be the principal drafter for the UPHPA. And that really hit home when, you know, after it was drafted, I started getting requests to present my work to various law faculties. And I remember, I think one of the first times I presented was at the University of Kansas. And so I just started my talk and started talking about the Uniform Law Commission. And, you know, I had some basic self-awareness after a couple minutes when I was looking at all these law professors who I was talking to at Kansas, who just looked like they had a glaze in their eyes, like they had no idea what I was talking about. And then I was like, and I'd be like, do you know what the Uniform Law Commission is? And most of them acknowledged that they didn't. And so what I always say is, have you heard of the Uniform Commercial Code? Right? Of course, everybody who's an attorney has heard of that. I said, where do you think that came from? And I said, it was actually the Uniform Law Commission, together with another organization, the American Law Institute, that drafted the UCC. And it has, the ULC has drafted now about 425 uniform acts in its 129-year history. So I was part of an ABA task force that we developed the idea for a uniform act and sent that proposal to the Uniform Law Commission back in 2007. And, you know, we were shocked actually that they accepted it, because they just didn't have a great record of kind of taking on projects that really implicated kind of social and racial justice. So every year the ULC gets somewhere between 50 and 60 proposals to draft a uniform act. They typically accept somewhere between 3 and 5. In my experience, most civil rights organizations, for example, have no understanding of the Uniform Law Commission. They have no idea this is a way of, could be a tool in their toolbox. So I think that there's obvious benefits. You know, Uniform Law Commission, there's about 350 Uniform Law Commissions in the country. They're all appointed by governors, so obviously they're connected. In Georgia, I think one of the Uniform Law Commissioners was in the Georgia Senate. I think he was one of the co-sponsors of our bill. I don't know if he's still in the Senate. I think it was Senator Lindsey. But that became the network of Uniform Law Commissioners can become incredibly helpful as you're trying to work that. So that's one of the things I've been trying to do, is increase awareness of the Uniform Law Commission among kind of civil rights and public interest groups, so that they can look at that as a tool. But I will say that we had some battles in the 3 years I drafted it. And some of the battles were just predicated on an act that really did implicate social and racial justice. There was this background assumption within the Uniform Law Commission that that was ultimately going to be a loser in terms of getting it enacted into law. I think it's been a bit of an education, frankly, for the Uniform Law Commission. Our act, as I indicated now, with 18 enactments, I think we rank as the 5th or 6th most successful of their uniform real property acts. There are 40 in their 129 years, and we're not done yet. I often say that I totally think that it's possible for us to get to 25 enactments by the year 2025. And so we'll just be ranked higher. And it's also been the Uniform Act that has gotten the most positive media attention for the ULC, like, I don't know, maybe ever, right? With coverage in the New York Times, the Atlanta Journal-Constitution, the Washington Post, Vice, which shows on Showtime. There's another cable show of Soledad O'Brien that's going to be coming out in March. The Houston Chronicle, the Chicago Tribune. I mean, papers. And I think that that's been a little bit of awakening for the Uniform Law Commission, that maybe they need to stop playing it so safe and more robustly take on issues that impact civil rights, social justice, the public interest, and not so safe. So I think it's been kind of a good kind of case study for them, which suggests that they might be more open going forward to kind of these to non-projects that have greater social significance, including in terms of racial justice.
Well, thanks. I have one more question for you, Thomas, and that's some outlook on further passing of the Uniform Act. Particularly, I think we have some questions in the audience about North Carolina, but where do you see, you mentioned California, so maybe you could talk about North Carolina, and then sort of talk about the special sauce it sometimes takes to get these things through the legislature, because it's not always about the good research and the good ideas.
Yeah. I mean, I love being a law professor and I love the academic side, but I also like where the rubber meets the road, and actually, like, how do you make things happen, right? And not just by your academic research or, you know, your brilliant legal arguments, right? And so so I think one of the things, you know, what we've learned in some states is we have to take a state-by-state approach. You have to figure out who are the important stakeholders. You have to develop what I call the ground game, you know, and trying to get a coalition together of various organizations. I would say in my work, I guess this is true in politics in general, that sometimes you have strange bedfellows or unexpected allies, right? And so for us, if you had told us 10 years ago that one of your potentially strongest allies in states where you would have a fight was the State Farm Bureau, you know, we didn't see that coming, right? I actually thought that the State Association of Realtors, because of that open market sale, where as opposed to the sheriff's sale or the judicial sale at the courthouse where there's no role for a real estate broker, under the open market sale, the court appoints a real estate broker who can earn their normal commission. I thought that they would be a likely ally. It took a while, like, for that actually to happen, but now we're seeing the fruits of that. In a number of states, we're seeing interest from the State Association of Realtors. So, you know, you got to think about the coalition. You got to, you know, open your mind to having allies that you might not have assumed that you would have. But then there's a certain amount of, you know, in some states, there's the fight has been more robust, right? In Florida last year, the Florida bar, basically they took preemptive action in 2019 and opposed the UPHPA, thinking that they had done the dirty deed that was going to kill any interest in the legislature. But because of the Farm Bill, we got an introduction last year, and they ginned up again to oppose. Now, I ultimately ended up having some people at the Florida bar reach out to me and said, no, they were actually quite supportive. And we had to develop a whole game plan to counteract the bars. It was actually the largest section of the bar, the real property, probate, and trust law section. And some of it was, I don't know, like hand-to-hand combat. And so I basically had to talk to them, and I said, listen, I'm going to tell you something. There's this federal farm bill, and I'm going to tell as many state senators and members of the state House of Representatives about the farm bill. I'm going to tell them why it's good for their constituents and why they might think it's good for them, right? And, they initially discounted it. They thought, no, the benefits are not that great. And, I actually followed through and did exactly what I said I was going to do. And when their lobbyist went to talk to these people in the legislature, he had to come back to them and say, it's time to raise the white flag, because all of them know about it. And it's not, the optics of us opposing it are horrible. So sometimes it's gotten a little testy, but, it's all respectful, right? It's vigorous advocacy. I don't say nasty words to them, but, sometimes you got to fight vigorously. So I think that, that's one of the things. The other thing I've had to let some of the folks I've worked with know is that sometimes leading with that this is a racial justice act is not the best strategy. So we've had, in Missouri in 2017 or 18, our bill got introduced. It was by a state senator and a member of their House of Representatives who were both African American. And they only framed it as kind of a bill to address racial justice. They didn't seek to build the coalition beyond that. And it failed. It failed miserably. It didn't even make it out of committee, let alone to the floor of either chamber for a vote. In 2019, a conservative white senator introduced it. He introduced it because a family friend of his lost their farm in a partition action, and that's where his consciousness was raised. So in Missouri, we explicitly did not try to frame it as a racial justice. We actually changed the name of it. And so in Missouri, it's called the Save the Family Farm Act. So sometimes you got to pull on some heartstrings, and you got to, tap into certain narratives where that's possible. And fortunately for us, this has been an act that has racial justice implications, but it's also one that we've been able to universalize. And I realize that's not true of every kind of issue implicating racial minorities, right? But it turns out that it was the case for us, and there was some benefit in certain states of framing it in a different way, right? And so we've done that. Now, what I'll say is that at the end of the day, I want the act enacted into law. It will benefit all these folks, including African Americans, even if we frame it in a different way. But I do see that there's a value sometimes of acknowledging explicitly the racial justice aspect. And what I'm happy is in the last year or so, with the momentum we've built up around the country, I'm able to address that. So for example, when I testified in the Florida Senate last year, I added a racial justice aspect to my 4 or 5 bullet points. Now, I didn't lead with it. Maybe it was point number 4 I raised, but I did think that there was some value in raising the awareness of some of the racial gaps and the racial justice. I showed them actually that slide about the racial will-making gap, hoping that if they passed the UPHPA into law, they might actually be motivated to do something to help narrow the racial will-making gap in subsequent legislation. But I felt confident enough that I could do that at that point without undermining our ability to prevail in Florida. So I think so I think it's that. The one last thing I do want to talk, Sarah, is a couple of the war stories from a couple of states. So I already referenced the Mark Zuckerberg experience in Hawaii. One of the most interesting and important places that we got this enacted into law, besides Georgia, which was huge, of course, was South Carolina. So in South Carolina, we were doing quite well in the South Carolina House of Representatives when I went and testified there. I think it was in 2016. And so I testified in a House subcommittee of the House Judiciary Committee. We got a unanimous vote. This is 2016. So as I was leaving, I had a member of the South Carolina House of Representatives tell me, he said, "You're golden. If you get a unanimous vote in the subcommittee, it's going to fly through the Judiciary Committee." So I was like, awesome. And then I only have one other thing to do before I leave Columbia is go take a picture of the Confederate flag in front of the state capitol just so I could show my family or, that there was still in 2016 such a thing. And then I was at a conference at the University of Georgia in Athens a week later, and I got a call or an email from one of the South Carolina Uniform Law Commissioners I had been working with, and he said, "Your bill is dead. The chair of the Judiciary Committee in the House has put a hold on it, and it's too bad because if it had passed, it would have really improved the conditions for all kinds of disadvantaged property owners in South Carolina. But I guess that's how the cookie crumbles." What I quickly found out is we had 2 weeks left in the legislative session. When I got back to Madison, or Wisconsin, where I was living at the time, I decided I'm not going to go down so easily. I'm going to try to throw every Hail Mary I could think of. And I ended up contacting the chairman of the board of the South Carolina Bar Association, who luckily for me was very familiar with heirs property and the problems. And he said, "Listen, your only hope is if I can identify a prominent real estate attorney in South Carolina who could then go talk to the head of the Judiciary Committee and try to get him to release his hold." He called me 3 days later. They had a Saturday coffee meeting. The chair of the Judiciary Committee did decide to release the hold. And then we, in the last 45 minutes of the legislative session, our bill passed. So that was in 2016. We were able to have our bill be considered by the South Carolina Senate the next year. Once again, I was hearing everything was going smoothly until it wasn't. And it wasn't as it was South Carolina Appleseed let me know that there were 2 right-wing senators who expressed all kinds of concerns. They asked me to write a memo addressing all those concerns that was disseminated to all of the members of the South Carolina Senate Judiciary Committee. Apparently my memo was convincing to one of the opponents or one of the people who expressed concerns, but there was a remaining state senator who had made it clear he was going to do everything possible to kill our bill. His name was Senator Paul Thurmond. His dad was somebody you might have heard of named Strom Thurmond. So now I feel like I'm battling the ghost of Strom Thurmond. And kind of a remarkable thing happened in the last couple weeks of that session. The sponsors of our bill in the South Carolina Senate decided to rename our act, which was the generic Uniform Partition of Heirs Property Act. And they kind of they leveraged a true tragedy, not just in South Carolina, but in our country. So it turns out that the minister or the pastor of that AME church in Charleston, South Carolina, where the white supremacists murdered the pastor and 8 or 9 members who were doing the Bible study. Turns out that that pastor was also a state senator, Clemente C. Pinckney. Clemente Pinckney was well known in the South Carolina legislature as being the person who was the fiercest advocate for disadvantaged property owners, including heirs property owners. And so at the last minute, they renamed our bill the Clemente C. Pinckney Uniform Partition of Heirs Property Act. It's the only bill in the South Carolina legislature that they've ever named after Clemente Pinckney. And as a result of renaming it, the state senators who were on the fence, right, who were considering supporting Paul Thurmond in his effort to kill it, all of them decided no, they were not going to vote against the only bill to honor Clemente Pinckney. And so the only person to oppose it in the end was Paul Thurmond, and it kind of sailed through there. So let me kind of end it on that.
Thank you, Thomas, so much. This has been really fascinating. The chats, you've just got so many people thanking you and complimenting you on the presentation. This was really excellent. Thank you to Sarah so much for moderating, and good luck, Thomas. Everybody, if you can, just go ahead and unmute and clap, please. We so appreciate you coming to Atlanta by Zoom, and we hope that when the pandemic's over, you'll come back and spend some time with us. We would love that.
Greg, I just want to thank you again. I was telling a couple of my friends, like I said, I deal with a lot of people in a lot of states, a lot of various organizations. I've worked with kind of amazing coalitions. Georgia had a really good coalition, which accounted for our success there in substantial part. And last year, great coalitions in both Florida and in Virginia, who I worked hand in hand with. But I do have to say that there's no other bar association in the entire United States that I've just kind of had this good vibe with, right? And I'm not sure why. Like, I don't know where exactly that came from. I don't, sometimes I say it's this zeitgeist of my family being, at least on my dad's side, from Southwest Georgia. Maybe that's kind of percolated up and it's just in the ether or something. But I would have to say that if there was any bar association that I would have wanted to have this kind of good vibes with, it would be the Atlanta Bar Association. So I'm just really thankful, and I hope on subsequent trips to Atlanta post-COVID, I hope to be able to sit down, break bread with some of y'all, have coffee with some of you all. So I really just, there's good feelings going both directions.
Absolutely. From us to back to you,
so
Thomas.
Thank you again for getting to present.
The zeitgeist is real so yeah, this is your home away from home. How about that?
Awesome. Yeah, great.
Thank you again. And thank you, Sarah.
And thank you, Sarah, right, for, my gang at the Fed.
Absolutely. God bless everyone. Stay well.
Okay. Bye-bye.